Good morning, this is your Kelso Report for Tuesday, November 1st, and I'm your host, Clark Kelso. Well, we start with two antitrust cases today, both from the 4th District. In both cases, the plaintiffs were unsuccessful. In our first case, the plaintiff could not allege an antitrust injury under the Cartwright Act, that is, an injury arising from anti-competitive conduct, as opposed to simply a case involving individual harm to a competitor. In our second case, the allegedly anti-competitive conduct was the result of a settlement of a lawsuit to enforce a patent. And since the settlement restrained competition only within the scope of the patent, it did not violate the Cartwright Act. Well, let's get along with our first case here in Marsh v. Anesthesia Services Medical Group. The 4th District considered a complaint alleging violations of the Cartwright Act, the unfair competition law, and a number of common law tort actions, including intentional interference with prospective contract. All of the claims arose out of the plaintiff's drop-off in business when she decided to separate from employment with the Anesthesia Services Medical Group, a professional medical corporation that provides physician services to hospitals and other medical centers in San Diego County. The plaintiff was a long-time member of the group, but decided to leave the group to pursue her own practice at a reduced rate of business. She wanted to work fewer hours. She negotiated a separation agreement to resolve outstanding disputes over professional fees, and the agreement included a non-disparagement clause. She alleged that after her separation, the group and Scripps Hospital, one of the major hospitals which contracts with the group for services, took steps to limit her opportunities to practice at Scripps or a related facility. She asserted that the defendants made knowing misrepresentations to interested parties that her employment status was retired, that she did not carry her fair share of call, and that she was disruptive, adversarial, and should be avoided. Scripps officials allegedly told surgeons that they were not allowed to specifically request her services, but instead must use group services. Unfortunately for the plaintiff, she was not able to allege any recognizable market in which the group and Scripps could plausibly exercise market power, and the inability to identify a market in which the defendant's allegedly anti-competitive conduct occurred, the plaintiff was left with allegations that simply she suffered a business harm, but without any allegation of antitrust injury. As the court noted, the antitrust laws were enacted for the protection of competition, not competitors. Injury to a competitor is not equivalent to injury to competition. That's the focus of the antitrust law. So, a complaint must allege facts from which injury to market-wide competition can be inferred. In other words, an antitrust injury must be proved. That is, the type of injury which the antitrust laws were intended to prevent and which flows from the invidious conduct which renders defendants' acts unlawful. Because the plaintiff could not allege an antitrust injury, the Cartwright Act claim was appropriately subject to a demurrer, as was the claim for a violation of the unfair competition law, which was premised on the identical facts. The court remanded the claim for interference with prospective advantage for further factual development. Essentially, that would involve additional allegations of improper actions by the defendants to interfere with the plaintiff's ability to secure contracts with surgeons and other buyers of anesthesiology services. So the common law claim there might go forward, but the antitrust claims were properly dismissed. In our second antitrust case, in re Cipro cases 1 and 2, the 4th District held that a settlement of a lawsuit to enforce a patent does not violate the Cartwright Act if the settlement restrains competition only within the scope of the patent, unless the patent was itself procured by fraud or the suit for its enforcement was objectively baseless. This decision arose out of a series of lawsuits filed by prospective generic manufacturers against Bayer beginning in 1991, challenging Bayer's patent in the chemical compound ciprofloxacin hydrochloride, the active ingredient in the drug Cipro. The patent in Cipro was not set to expire until June 9, 2004. Now, after substantial pretrial motions in those lawsuits and the denial of cross motions for summary judgment, Bayer entered into a settlement agreement with the plaintiffs, as well as a few other generic manufacturers waiting in the wings, pursuant to which the validity of Bayer's patent was acknowledged and Bayer's right to be the exclusive provider of Cipro was recognized until expiration of the patent, in return for substantial payments to the plaintiffs, a type of settlement that has come to be known as a reverse exclusionary payment settlement. The settlement agreement triggered another wave of lawsuits by other potential generic manufacturers who claimed that the settlement agreement itself violated the Cartwright Act. After balancing the somewhat conflicting interests represented by the patent laws, the antitrust laws, and the policy favoring settlement of claims, the 4th District decided to follow the lead set by the United States Court of Appeals for the Second Circuit in re tamoxifen citrate antitrust litigation, where the Second Circuit held that unless and until a patent is shown to have been procured by fraud, or a suit for its enforcement is shown to be objectively baseless, there is no injury to the market cognizable under existing antitrust law, as long as competition is restrained only within the scope of the patent. Applying this legal test to the facts, the 4th District concluded that the Cipro settlement agreement restrained competition only within the scope of the patent. There was no evidence of fraud in securing the patent, and no evidence that Bayer's suit for enforcement in the 1990s was objectively baseless. Given these conclusions, the 4th District affirmed the trial court's decision to grant summary judgment to Bayer and the generic manufacturers who were party to the settlement, and to dismiss the action. In short, Bayer was given the benefit of its patent, and the antitrust laws were appropriately put to one side until expiration of that patent, subject only to the terms of the settlement agreement. Well, now we go to today's one-liners. We begin first in the area of labor law, where in Small versus Avanti Health Systems, the 9th Circuit upheld the District Court's preliminary injunction directing a successor healthcare employer to recognize and bargain in good faith with the California Nurses Association as the exclusive bargaining representative of the nurses. The defendant had purchased a hospital from its owner during bankruptcy proceedings, and the parties agreed the defendant was a successor employer. So the only issue was whether a majority of the current nurses were in the nurse bargaining unit in the predecessor employer. The lower courts analyzed this question by examining the first payroll of the successor employer and determined that over 60% of the nurses had been in the nurse bargaining unit of the predecessor employer. Accordingly, the plaintiff had established a likelihood of success in support of its request for a preliminary injunction, and all of the other factors supported a preliminary injunction. So the 9th Circuit affirmed the trial court's issuance of that preliminary injunction. Next, in the area of evidence law, in People v. Vang, the California Supreme Court clarified that an expert may render opinion testimony on the basis of facts given in a hypothetical question that asks the expert to assume their truth, even when that hypothetical very closely tracks the evidence in the case. Indeed, as the court notes, it would be surprising if the hypothetical facts did not closely track the evidence in the case, since the further away from the evidence the hypothetical moves, the less relevant it would seem to be to the case. Accordingly, the court reversed a Court of Appeal decision which had condemned the hypothetical questions used in this case to explore the circumstances under which an assault was gang-motivated. The Court of Appeal's concern was that the hypothetical question was so close to the evidence that the expert's opinion was a virtual directed verdict on the question of the defendant's motivation for the assault. The Supreme Court disagreed, noting that the jury is more than able to distinguish between the expert's answer to a hypothetical and its own ultimate role in making factual determinations and finding guilt. Next, in the civil law area, auctions is the topic in Biancalana v. TD Service, where the 6th District held that in the foreclosure of a piece of real property at a trustee's sale, where the mortgage service company had incorrectly told the auctioneer that the opening bid amount was only $21,894, when in reality the opening bid amount should have been $219,000, the service company's negligence did not render the sale of the property voidable. According to the court, the service company's negligence was entirely outside the procedures of the auction, and since there was no procedural irregularity in the foreclosure sale, the purchaser was entitled to the property at his bid amount, which was the opening bid amount. Now, it would seem here that the purchaser has achieved a bit of a windfall at the expense of the service company, but adherence to the statutory procedures for foreclosure sales is in fact designed to streamline the process and reduce uncertainty by making the sale final if made to a bona fide purchaser. The buyer in this case seems to have made a very good deal. Next, in the area of attorney's fees, in Serrano versus Stefan Merle Plastering Company, the California Supreme Court upheld attorney's fees to the plaintiff under the Private Attorney General Statute, CCP Section 1021.5. The plaintiff successfully secured a ruling that an extra fee charged by deposition reporters for an expedited transcript, which had already been noticed by another party, was unreasonable. The Deposition Reporter Service defended the extra fee, in part by citing its status as a ministerial officer of the court and its need to control the fees it charges. It argued that even though it had lost this issue on the merits, it nevertheless should not be responsible for attorney's fees, because it was only seeking to vindicate its private rights instead of trying to defend a public right. And, according to the Supreme Court's decision and in adoption of Joshua S., a Section 1021.5 fee award may not be imposed on a litigant who did nothing to adversely affect the public interest. Well, the Supreme Court yesterday rejected the application of Joshua S. to the facts of this case because the deposition service was in fact doing more than just protecting its own interests. It was engaged in an effort to protect the institutional interests of all deposition reporters. And given that it was found to have charged an unreasonable fee for those services, it was clear that it in fact had done something to adversely affect the public interest. Next, in the area of probate law, in Hernandez versus Kieferl, the 2nd District held that the probate court had erroneously invalidated an amendment to a trust which named a care custodian as the trustee and sole beneficiary of the trust estate. The probate court held the amendment failed under Probate Code Section 21350, which establishes a rebuttable presumption that testamentary transfers to care custodians are the product of fraud, duress, menace, or undue influence. The 2nd District reversed, concluding that the probate court erred in failing to apply the exception to the presumption that is found in Section 21351, where the transferor is related by blood or marriage to the transferee. In this case, the transferee was the transferor's stepdaughter by marriage, so the exception to the presumption should have applied. And that's it for today's Kelso Report. Have a great day in the law.